Please the court. Ladies and gentlemen of the jury, I first want to thank you on behalf of all my co-counsel and opposing counsel, and thank you for the time you put into this and for listening closely and carefully to the evidence that you've heard today. First, the judge will give you some instructions, and he will instruct you that the plaintiff, which is Plaintiff Larry Kane, must prove by a preponderance of the evidence, 1, that he's a United States citizen, 2, that the defendant deprived him of his constitutional right to be free from unreasonable searches and seizures by using excessive force in apprehending him. In considering whether the excessive force was used by Officer Bond, you may consider the following factors. You have to consider the severity of the crime, whether the plaintiff posed an immediate threat, whether the plaintiff resisted or tried to flee, and what a reasonable police officer would have done in that situation. The third element is that plaintiff was injured as a proximate cause of the police officer's conduct. Also, you must find that the defendant acted under the apparent authority of state action. And finally, that the defendant acted intentionally. I'm going to go over each of these elements and show you how easy this will be to find that the plaintiff has met his burden. First, plaintiff testified that he was born in the United States, so he's a United States citizen. Number 2, that the defendant deprived him of his constitutional right from excessive force. In this case, you've heard testimony that Officer Bond obviously used excessive force in trying to allegedly apprehend the plaintiff. Plaintiff testified, and you heard testimony corroborating his testimony by his girlfriend, Ms. Curtin, that Officer Bond had a vendetta against the plaintiff, that he was jealous of him because plaintiff was dating someone that Officer Bond was trying to date. You've heard that the plaintiff did not try to attack, that he did not threaten to attack or harm Officer Bond at any point on July 6th when he was shot twice. You've heard that Officer Bond, when he first arrived on the scene, stated that plaintiff had caused the accident, even though he had not gathered any information. He automatically went and blamed plaintiff. You have heard that plaintiff was upset, obviously, because he had just been involved in an accident, but what made him even more upset was because an officer who's supposed to be unbiased in investigating the facts of a car accident, he came up and immediately started blaming him for causing the accident. And without provocation, without any warning, Officer Bond, out of nowhere, hit the plaintiff with his nightstick. Now, the plaintiff never tried to flee. He said he testified that he went to go cool off in his car. The door was still open. He never tried to flee this accident scene. But yet, Officer Bond rushed up to him, pulled him out of the car, and hit him on the head with the nightstick. And as if that wouldn't subdue someone, he hit him twice with the butt of his gun for no reason, no provocation. Not once did plaintiff try to harm or threaten to harm Officer Bond. Plaintiff was merely trying to protect himself from an enraged officer that he knew had a vendetta from him based on the incidents that happened on July 4th at the party and based on the fact that Ms. Curtin numerously rejected his advances. Okay, let's talk about the factors you are to consider. The severity of the crime. What crime? He had just been involved in a minor car accident, a fender bender. So there was no severe crime, no murder, no assault, nothing to warrant Officer Bond's excessive force. Okay, 2, whether the plaintiff posed an immediate threat. As I stated, he never once tried to attack the officer. He was merely trying to protect himself from being attacked by an enraged officer. He never posed an immediate threat. He never said, I'm going to shoot you with a gun, I'm going to beat you up, or anything like that. The third factor, whether the plaintiff resisted or tried to flee. As I stated, he never tried to flee. He sat in his car the whole time. He couldn't go anywhere because his car was stopped. It couldn't start up, so he couldn't drive off the scene. And whether he resisted, he never resisted. When he got out the car, Officer Bond never even gave him the chance to get out of the car. He pulled him, dragged him out of the car. So it's not like he was trying to resist arrest or flee. Number 4, what a reasonable police officer would have done. You're smart, you're intelligent, you have common sense. You know what reasonable police officers do in certain instances. If a police officer is called to, say, a fire has gone off at a house or there's been a shooting, you know how police officers use excessive force in those dangerous situations to subdue a dangerous person. In this instance, he was called out for a minor car accident. Why did somebody have to end up being shot twice, once in the back and once in the wrist? That's not what a reasonable police officer would have done in this circumstance. And even though Officer Bond states that he allegedly felt threatened for his life, when police officers feel threatened, they call for backup, especially if you're a 2-month, you've only been on the force for 2 months, you're still in training. You don't call for backup when, first of all, you know you're not supposed to have a gun, a personal weapon. So technically, he wasn't even supposed to have that use of excessive force, but he had it in violation of the city's policy. But if he was so threatened, if he was so in fear for his life, a new cadet, a new police officer would have immediately called for backup. He was the only person on the scene with the color of authority of a police officer. There were 2 people there. One was involved, both were involved in an accident, and then there were innocent bystanders. So in that situation, a new officer would not have tried to tussle and attack one person. He would have called for backup immediately. Okay, the third element, the plaintiff was injured as a proximate cause. Obviously, you heard testimony from the plaintiff that he was obviously injured. He went straight to the hospital, rushed to the hospital. He had to get surgery on his liver. He had a wrist on his right arm, on his right wrist, due to the bullet fracturing his bone. He had headaches constantly. He had 3 abrasions on his head from being beat with a nightstick and beat 2 times with the butt of a gun. He had, obviously he had pain. He had to get medication to subdue that pain. He couldn't sleep. The doctors had to tie him down to a hospital bed so that he could not move. But yet he had to sit there and lay there and endure that pain for those 2 weeks that he was in that hospital. And you heard the testimony from the plaintiff that even today he still does not have the full use of his right arm because he used to be able to play basketball. He used to be able to do heavy lifting, but today he still cannot do that because of this incident. So that's the third element. 4th, defendant acted under the apparent authority of a state statute. Obviously, defendant acted under authority. He was in his police uniform the entire time. He had been called out to duty. He even testified, the defendant testified that he was on duty at the time of this accident. So he was under the authority of a state statute. He was a police officer acting under the direction of his chief of police. Number 5, defendant acted intentionally. There has been numerous amounts of evidence about defendant acting intentionally. He intentionally hit plaintiff on the head with a nightstick even though he was not provoked and even though plaintiff did not pose a threat to him. He intentionally beat him 2 times with the butt of his gun, again, even though plaintiff had not posed a threat to him. He also deliberately bent down on one knee, did not call or give out any warning. He did not say freeze or I'll shoot. He did not say stop or I'll shoot. But he had time to bend down on one knee and fire the gun 6 times. That means there were no bullets left in this gun. Bent down, fired the gun. 1, 2, 3, 4, 5, 6 times. And he hit him twice. He hit someone in the back, meaning plaintiff could not have been turned around. He could not have been trying to attack Officer Bond. He had his back turned to him trying to get to safety, but yet he was shot in the back and in the wrist. And he could have been shot numerous more times because, as I stated, fired his weapon 6 times. But he was hit twice, once in the back and once in the wrist. So, as far as Officer Bond, you have numerous amounts of evidence to find that plaintiff has met his burden of a preponderance of the evidence that defendant is guilty of excessive force. Now, with regard to the city, plaintiff must again prove that he's